Banking secrecy in Malaysia is mandated by law as stated in the Financial Services Act 2013. At all times, a banker owes a duty of secrecy to its customer, including the duty to keep information concerning its customers' affairs confidential. This includes the duty to keep the information private. This responsibility is likewise contractual in character, and it's to be indicated by the relationship that exists between a banker and a customer. Section 133 subsection 1 of the Financial Services Act 2013 stipulates that no person who has access to any documents or information relating to the affairs or account of any customer of a financial institution, including the financial institution or any person who is or has been a director, officer or agent of the financial institution, shall disclose to another person any document or information relating to affair or account of any customer of financial institution.
Assalamualaikum and hi everyone. My name is Khairul Najwa binti Muhammad Tua and my metric number is 275654. I will continue presenting about the scope of a banker's duty of secrecy and confidentiality in Malaysia. I will discuss this section with the case of Tournier versus National Provincial and Union Bank of England. In this case, the bank disclosed to plaintiff employer about the plaintiff information which he had obtained from the drawer of cheque made in favor of plaintiff. After receiving the information from the bank, the plaintiff employer did not renew the plaintiff contract of employment. The plaintiff then commenced an action of breach confidentiality. The court held that the right of customer to have his affair kept confidential is a legal right, which is not absolute but qualified. A banker has a duty to keep a customer's secret and trust. This includes not only information and facts that he learns from the customer account, but also information that he learned from sources other than the customer account because of their banking relationship. With this case, it shows the correct definition of the scope of banker's duty of secrecy and confidentiality to its customer. Next, I will pass the presentation to the next presenter.
The concern is that does the obligation of the duty of secrecy is bound to a former bank employee? The simple answer to the question is yes. Section 133 subsection 1, which is read together with Section 133 subsection 3 of the FSA, makes clear that the obligation of secrecy extends beyond bank employees to anybody else who comes into contact with private information. The duty of confidentiality encompasses a person who is not just a bank officer, but even a third party. It is stated in Section 133 subsection 3 of the FSA that a person who has any information or document that to his knowledge has been disclosed in contravention of Section 133 subsection 1 of FSA is prohibited from disclosing the same to any other person. Even when the relationship between the banker and the customer has ended, the banker is still under an obligation to maintain confidentiality. In other words, a banker has a duty to keep a customer financial information private and confidential, and this duty not only encompasses the information and facts that he learned from the status of the customer's account, but it also includes and extends to any information gained about the customer from sources other than the customer's actual account through the banking relationship. As a consequence of this, in the case that a banker violates his duty of confidentiality, the customer may be entitled to demand damage if he had incurred losses as a result of the breach. When a customer successfully sues a banker for breach of duty of confidentiality, the amount of damage that the customer is entitled to recover depends on whether or not the customer is able to establish the actual extent of the damage that he had suffered as a result of the disclosure.
So we proceed to the second entry burglary. The Kuala Lumpur Section Court Centre on order on fine of 1,500 or 7 months in jail for a period 673 days. On the 3 charge, Okarkian was charged with failing to appear before the SC investigating officer as required under Section 32 3A of the Anti-Money Laundering and Anti-Terrorism Financing Act, AMLA-TFA. The offence was committed at the SC headquarters at Persiaran Bukit Kiara here on between April 16 and June 4, 2018. Hello, I'm Nur Ashiki Minta Azmi, 273-276. So I will present the case. In the case of Tan and Song versus Malayan Bank Berhad, the plaintiff who was the bank employees had left and orally closed his bank account with the bank without giving any written instruction. The bank did not close the account as there was no written authorization from the plaintiff. Lying dormant, the service charge and interest on the account accumulate to 50 ringgit. The bank credit officer subsequently informed the plaintiff brother, and upon knowing the plaintiff comments and action for breach of confidence, the court held that the plaintiff failed to close his account as the required written instruction was not given. The alleged statement made by the bank credit officer was not defamatory.
My name is Siti Khadijah binti Anwar Hakim, matrix number 272283, and I'll be presenting the exceptions of a banker's duty in confidentiality in Malaysia. There are a few exceptions that allow a banker to break customers' confidentiality and disclose their information, which is directed by a court order or compulsion by law to protect the bank's interest, disclosure for public interest, and if consent is given by the customer either impliedly or expressly. The exceptions provided under the statute are of the following: Section 133, Subsection 2, Subsection A of the FSA, where the disclosure is for the purpose of exercising any powers or functions of the bank under the FSA or the Central Bank of Malaysia Act 2009. Next, Section 133, Subsection 2, Subsection B, where the document or information is in the form of a summary or collection of information set out in such a manner as it does not enable information to be ascertained from it. Next, Section 133, Subsection 2, Subsection C, where it's not applicable to the information lawfully available to the public from any source other than the bank. I will also present some of the exceptions under Section 134, Subsection 1 of the FSA, which is read together with Schedule 11, where it clearly stipulates that the information is permitted to be divulged if written consent is given by the customer or his personal representative, if the customer is declared bankrupt or wound up for the purpose of legal proceedings, either criminal or civil, where the financial institution is a party to it, for the purpose of fulfillment of a garnishee order, to comply with court order made by a court not lower than a sessions court, to comply with an order or request made by an enforcement agency in Malaysia under any written law for the purpose of an investigation or prosecution of an offence under any written law, for the performance of functions of the Malaysia Deposit Insurance Corporation, and also disclosure by a licensed investment bank for the purpose of performance. Other than that, if documents or information are required by the Inland Revenue Board of Malaysia for taxation purpose, disclosure of credit information of a customer to a credit report agency registered under the Credit Reporting Agency Act 2010. It is only by the above-mentioned qualifications or exceptions that such information may be disclosed legally to a third party. The bank can raise the exceptions as a defense against any claim made by its customers.